rise.
Thank you. Please be seated. Yes, Ms Shepherd, thank you.
Thank you, Commissioners. I appear with my learned junior, Dr. David Townsend, and I thank the Commission for accommodating our appearance at this time. Commissioners, you have Mr Felsted's written submissions. I'll also be making reference to Mr Felsted's summary of argument if you have that to hand. Might I commence by saying that Mr Felsted made significant concessions adverse to his interests in the Bergen inquiry. Nothing now said is intended to resile from those concessions or the findings of the Bergen inquiry understood in their proper evidentiary context. Mr Felsted disputes 7 findings proposed by counsel assisting, and some may properly be described as intermediate findings. Each disputed matter is pressed. The matters canvassed by the disputed propositions are, in our respectful submission, serious. At a general level, they canvass the sorts of matters which might inform prosecutions under the Corporations Act for breaches of directors' duties or prosecutions under the Gaming or Wagering and Wagering Commission Act, in particular Section 29, which makes it an offence punishable by imprisonment or fine to knowingly or recklessly make a statement which is misleading to the GWC. It is our respectful submission that this commission, consistent with the standard applied in similar commissions of inquiry, ought to apply the civil standard informed by Brigginshaw principles. That is, that this commission ought to be satisfied that each finding is based on compelling evidence and not inexact proofs, indefinite testimony, or indirect references. In this respect, we invite the Commission to pay careful regard to the evidence said to support each proposed finding. We have detailed in our submissions where we say the evidence is wanting. Precise findings of Mr Felsted's knowledge were made in the Bergen report. Singularly or combined, these do not support the findings now proposed. For example, that Mr Felsted knew all matters relevant to the China arrests. Now, if this commission is to go beyond the findings made in the Bergen inquiry, it should do so in our respectful submission based on compelling evidence and not on assertion or generalisation. Our submissions detail other concerns with respect to the disputed proposed findings, and I do not intend to go through each one. However, 2 findings warrant special attention. And if I might bring your attention, Commissioners, to point 2 of the summary of argument. The focus of my address is 2 findings. The first of which is that the effect of Mr Felsted's evidence is that he was aware of facts that indicated that CRL had disregarded the welfare of its China-based staff by exposing them to the risk of detention in China. Now, this may be what is called an intermediate finding. It is no less significant for that because it is a stepping stone to ultimate findings, including the one immediately below it, as referred to at point 2 of the summary of argument. Now, the effect of Mr Felsted's evidence in this and other inquiries is that he has never admitted that he was aware that Crown had disregarded the welfare of its China-based staff, or that he was aware of matters which indicated to him that fact. No finding to that effect was made in the Bergen inquiry based on his or other evidence. The effect of Mr Felsted's evidence is that at the relevant times, he had always thought Crown had put in place measures to safeguard staff, including obtaining legal and strategic advice. And that's set out at, in our written submissions at paragraphs 10 and 27. The fact that in hindsight, these safeguards proved to be inadequate and Mr Felsted's trust in them was misplaced does not mean that Mr Felsted's belief was not genuine at the time. Further, it does not mean that Mr Felsted's expectation that the China staff would not be arrested and convicted lacked any reasonable basis. And this must be so where Crown's advice was that the China staff were not engaging in illegal conduct, and that was found to be the case in the Bergen inquiry. To make good those propositions, can I take the Commission to two pieces of evidence in the Bergen inquiry and which have been tendered in this forum but have not previously been brought to your attention? The first piece of evidence I wish to go to is Mr. Felsted's witness statement dated 17 December 2019, which is document CRL.540.001.0114. If I might ask the operator to turn to page ending 0129 of that document, which is internal numbering page 15. And I direct your attention, Commissioners, to paragraphs, starting at paragraph 49. And it's headed, "My Assessment of Risk in China During the Relevant Period." Mr. Felsted deposes that he, at all times during the relevant period, which is defined to be the 6th of February 2015 to 14 October 2016, he understood on the basis of the advice obtained from Wilmer Hale that Crown's operations in mainland China were legal according to the laws of the People's Republic of China. And turning over to the page, further, he did not think that there was a risk that Crown's China staff would be prosecuted or convicted for gambling-related crimes, or that Crown's operations in China would be stopped. Paragraph 15 makes reference to the activities of other casinos. And at paragraph 51, halfway down the page, Mr. Felsted says that he travelled regularly to China. And then, in particular, "I travelled to mainland China on 3 occasions in 2016, being in May, August, and early October. On the last of those trips, I was accompanied by my wife. I would not have travelled into China to meet with customers or taken my wife into China if I considered that there was a risk I would be arrested." The next piece of evidence to which I wish to take you, Commissioners, is Mr. Felsted's transcript of examination in the Bergen inquiry, which is document BGN.0002.0001.1251. And can I ask the operator to go to page ending 1372 or transcript 1374? Now, about line 22 of that page, Commissioners, you'll see that Mr. Felsted has asked the question, now, did travel to the mainland resume for executives in the VIP division in 2015? To which Mr. Felsted says, yes, it did. And he indicates at about line 28 that for him personally, he went back in China in early May, and that's of 2015. Mr. Felsted further volunteers that he made 2 more trips in 2015. And further down the page at about line 39 to 40, he's asked about discussions about the resumption of travel between him and other members of the VIP division. And turning over the page to page ending 1373 or 1375 of the transcript, at line 6, Mr. Felsted is then asked about the factors that he personally took into account in deciding that it was appropriate to resume travel. At lines 7 to 11 of that page, Mr. Felsted says that he took into consideration the fact that they were receiving advices from Mints our agency that it was right to travel, and advices from Wilmer Hale as well, and general information about what other properties were doing in China. And then turning your gaze further down that same page at about line 39, line 32, Mr. Felsted then asked about his trips in 2015 and 2016 being accompanied by his wife. And at line 39, Mr. Felsted says, yes, that was the very last trip. That was in around October 6, October 7 of 2016. Now, I interpolate there to say that the China arrests were coordinated raids that were conducted on the 13th and 14th of October 2016. And so Mr. Felsted was in fact visiting China in the weeks before that occurred. He's then asked whether he had any concerns about his personal safety and risk of detention. He answers that he did not. Then turning over the page, he's then asked, naturally, whether he had any concerns for his wife's safety. He said that he did not. And he's asked about the risk assessment that he took in conducting himself and his wife to travel to China. And he answers at line 10 that he was relying upon the consistent advice that he'd received from Wilmer Hale and Mintz. And he was thoroughly satisfied that was sufficient. I felt in no danger or threat going there or taking my wife there. Now, this evidence must be contrasted to the proposed finding, and it's the proposed finding that the effect of Mr. Felsted's evidence, that he was aware of facts that indicated that Crown had disregarded the welfare of its China-based staff by exposing them to the risk of detention, is difficult to reconcile with the evidence to which I've just taken you, and nothing tendered or said in this commission by Mr. Felsted lends support to the proposed finding by counsel assisting. If I might turn back to point 2 of the summary of argument and the second proposed finding, the subject of these oral submissions, that concerns the August 2017 presentation, which says that it's open to infer that, or open to find that Crown carelessly made the statement to the effect that the arrest of its China-based staff was unexpected. There's a reference then to what Mr. Felsted would have known, and that either his knowledge was not effectively conveyed or inadequate inquiries had been made. And it's particular reference to the last sentence, which is that in any of these cases, it is open to the PCRC to find that either Preston or Mr. Felsted were careless. Now, and I'm turning to point 8 now of the summary of argument. Counsel assisting does not indicate how Mr. Felsted may have been careless, and no careless act or omission arises from the evidence. And this is made good at paragraphs 29 to 46 of our written submissions. In particular, Mr. Felsted did not author, approve, present or participate in the August 2017 presentation. He had no involvement in the preparation of the PowerPoint, nor did he attend the meeting where it was presented. Now, no criticism is made of counsel assisting, who had a number of topics to cover with Mr. Felsted in his full day of questioning, but the simple fact is that this topic was not one of them. Mr. Felsted's statement said nothing more than that he was aware that a presentation had been given to the GWC. There's no evidence that he knew of the contents of the presentation or even what was said. There's no evidence that any of the Crown employees or legal teams involved in the presentation sought his contribution. So what the Commission is left with is nothing more than assertion and indirect inference to support the proposed finding. It's a serious finding. It asserts Mr. Felsted acted carelessly in performing his duties as an officer in the context of alleged misrepresentations to the GWC, which is, as indicated, is a potential offence. This sort of finding ought not be made on the basis of the evidence presented. There is a further vice to the finding. It suggests that if someone had spoken to Mr. Felsted, he, with his knowledge of events, should have said that he or Crown anticipated or expected the China arrests. Now, no finding in the Bergen report went that far. What the Bergen report says is that the significant risk of arrest ought to have been appreciated by Crown and its officers. It was not. That was the vice. However, a failure properly to appreciate the risk of an event does not thereby make the event one that was in fact expected. As it was, there is no evidence that Mr. Felsted was asked his view either way on whether it was expected or whether that view ought to be conveyed to the GWC. Unless there is anything further, those are our submissions along with our written outline.
Thank you, Ms. Shepherd. Any questions? Thank you.
No, I don't have any questions.
Ms. Shepherd, we don't have any questions we want to raise with you. We will consider once again all of the written materials, and we thank you very much for your presentation today. Thank you.
Thank you, Commissioners.
And I'll now invite Council Assisting to make some final remarks.
Thank you, Commissioner. As foreshadowed by Commissioner Owen yesterday morning, these remarks are confined to responding to the oral submissions made over the last 2 days by interested parties. It's not intended to address each and every submission that has been made. Rather, the intention is to focus on particular issues. That is, first, where submissions have been made about the approach it is said that the PCRC should or must take as to a particular issue, or where submissions have been made as to a finding that the PCRC should or should not make on an issue, and to then elaborate upon the range of matters that will be relevant for the PCRC to take into account in that regard before it reaches a final conclusion about its approach to certain issues and findings that it should make. Whether Commissioners have already, through their questioning of Council during the course of yesterday and today, already elaborated these matters themselves in respect of certain issues, I don't propose to repeat anything that has already been said. I begin by addressing some general matters of approach. It's been submitted by more than one interested party over the last couple of days in substance that the PCRC must proceed with caution in making any adverse findings against individuals. That caution is expressed as a reminder to observe the Brigginshaw principle and to make only such adverse findings against individuals as are necessary. So much may be accepted, but that caution, of course, applies equally to all adverse findings against all parties, entities, as well as individuals, including the interested parties. With respect to the position of individuals particularly, much of the PCRC's inquiry is concerned with identifying not the failings of individuals on any specific occasion, but rather systemic deficiencies in an organisation's practices and processes which may compromise, respectively, the effectiveness of the GWC or the suitability of the relevant Crown entities. In that context, it may on occasion be necessary to identify and make findings about the conduct of an individual in order to identify what is not a systemic deficiency, or to explain how a systemic deficiency in fact occurred. There may also be occasion where it is necessary to make a finding about an individual who remains integral to how a system operates and thereby contributes to an ongoing systemic deficiency. The CPH parties have submitted that the PCRC should be cautious in its treatment of the findings of earlier inquiries. The terms of reference require the PCRC to have regard to the Bergen report and the matters referred to in it, including findings. The terms of reference also expressly state that the PCRC is not required to inquire or to continue to inquire into a particular matter to the extent that it is satisfied the matter has been or will be sufficiently and appropriately dealt with by another inquiry or investigation or a proceeding. The PCRC's obligation in the former case and its discretion in the latter would appear to be directed to avoiding the situation where public monies are used to duplicate another inquiry when it is unnecessary to do so. Whether duplication is necessary or unnecessary needs to be considered by the PCRC on a case-by-case or finding-by-finding basis. It is likely to be very relevant to that consideration if a finding is conceded by a party against whom it is made or proposed to be made. Where there is no concession, further inquiry may be necessary in order to ensure procedural fairness. What that further inquiry might entail will depend again on the circumstances. So, for example, the absence of an interested party from a previous inquiry may militate against reliance on relevant findings in themselves, although the underlying evidence gathered in that previous inquiry may, in appropriate circumstances and on notice to the interested party, be used to enable the PCRC to make its own findings. I turn now to make some observations about Part B of the Terms of Reference that inquire into aspects of the regulation of Perth Casino by the GWC and the Department's support of the GWC in that regard. Counsel for the GWC made two related submissions focusing on apparent constraints under which the GWC has operated and, at least to some extent, may continue to do so. The first was to characterise the GWC as essentially a volunteer body. That presumably must be understood as challenging the adequacy of the remuneration paid to GWC members, having regard to the relative importance and complexity of the statutory function members undertake. If the PCRC were to conclude that the remuneration of members is and has been generally inadequate, that might suggest, as a matter of practical reality, that it may be difficult to attract members of suitable ability with appropriate experience to agree to serve on the board. However, once a person has accepted a role as a member of any statutory board, including the GWC, it is a more contentious proposition to contend that the breadth of governance responsibility that is assumed or the diligence that is to be applied to that role is influenced by the level of remuneration a member receives. The second constraint Counsel for GWC identified was said to be a financial one arising from Section 7, subsection 2 of the GWC Act. GWC submitted that this provision effectively requires that the GWC is, as Counsel phrased it, to live within its means. Counsel then went on to identify those means in respect of casino gaming regulation as being principally revenues derived from the casino tax. The PCRC will need to consider the effect of the relevant statutory provisions on this point, in particular whether Section 7, subsection 2 does restrict the resources available to the GWC, or whether that provision may, properly construed, in fact provide for the opposite, namely to oblige the GWC to ensure that it derives revenue sufficient to enable it to properly and adequately discharge its functions and responsibilities. Separately, it should be noted that pursuant to Section 9 of the GWC Act and Section 14 of the Casino Control Act, the funds available to the GWC include appropriations from Parliament, and it may be relevant to consider whether any appropriations have been sought or granted. Counsel for the Department drew attention to the statutory framework and submitted that it established the role of the Department to support and assist the GWC in the exercise of the GWC's statutory functions, noting that the Department itself is not charged with any statutory decision-making role as the GWC is. There are two observations to make about that submission. The first is that the PCRC will again need to carefully consider the statutory framework in particular Section 18 subsection 1 and Section 19 of the GWC Act. The former provision suggests that by arrangement, departmental officers may effectively be seconded to the GWC on a full-time or part-time basis. The latter provision suggests that a government department such as this one must assist the GWC if and as directed by their responsible minister. The second point is to examine the detail of precisely how the department has assisted the GWC in practice, to consider whether the respective roles of the GWC and the department have been as neatly separated as the department appears to contend. The issues that emerge for consideration in that regard include the extent to which the department has acted or purported to act on behalf of the GWC to exercise the GWC's powers and discharge its statutory responsibilities, whether by delegated authority or otherwise. The extent to which the GWC has overseen any exercise of its powers or discharge of its responsibilities by the department on its behalf. The extent to which the department has made itself accountable to the GWC in that regard, and the clarity and unity of understanding on the part of each of the GWC and the department about those matters. One particular example on this topic, addressed by counsel for the department yesterday, concerned the most recent appointment of the Chief Casino Officer, purportedly by the department, on the basis that Section 9 of the Casino Control Act does not specify by whom the appointment should be made. One question that emerges there for the PCRC to consider is how the department exercised power to make that appointment, and whether, for example, that required delegated authority from either the responsible minister or the GWC, and if so, whether that was obtained. Another example of the interaction of roles between the GWC and the department arose in submissions of both the department and the GWC in relation to policy development. The department submitted that it has a responsibility to instigate policy development. The GWC submitted, however, that it is it that has that duty expressly and under Section 7, subsection 1 of the GWC Act, albeit that for practical purposes, the resources to enable the GWC to formulate policy reside within the department. So the matters for the PCRC to examine include whether the demarcation of roles and responsibilities as between the GWC and the department in relation to matters such as policy formulation and development are sufficiently clearly and correctly understood on each side. Counsel for the department made submissions about a number of reforms said to have been instigated by the department as a result of this inquiry, with respect to the systems and processes of both the GWC and the department. There are a couple of observations to be made too about those submissions. Presumably they are intended to be relevant to the assessment of the current effectiveness and capability of the GWC and the quality of the support provided by the department to the GWC, that is, terms of reference paragraphs 9 and 10. However, the PCRC will need to consider the weight that can be attached to such submissions, that weight being affected by whether and the extent to which they are supported by evidence the PCRC has received. A further issue that arises is the level of generality at which submissions may have been expressed as to a reform program that do not permit the PCRC to meaningfully examine or interrogate their substance. I'll return to Part B briefly in a moment in the context of some specific remarks about harm minimisation, but I now move to make some observations relevant to Part A of the terms of reference. The exercise under paragraphs 1 to 5 of the terms of reference to inquire into and report upon whether the entities specified in those paragraphs are each a suitable person in respect of the activities designated there does not call for the granting or withholding of sympathy by the PCRC as suggested by counsel for GWC yesterday, nor the granting or withholding of punishment as referenced by senior counsel for the Crown entities yesterday. The exercise is rather an objective one, albeit that it involves weighing a number of factors to reach a conclusion on those topics. Crown has submitted that the requirement for the PCRC to assess present suitability invites attention to the past as well as the future to assess the present position. To elaborate a little further on that, under the terms of reference, the inquiry into an assessment of suitability is suitability as at the date of the delivery of the final report, which is presently anticipated to be 4 March 2022. As Commissioner Owen noted yesterday, there are some practical limitations that affect that inquiry. The most obvious being that the formal evidence gathering phase of the inquiry has necessarily concluded at an earlier date than 4 March to allow for procedural fairness to be afforded to interested parties and the final report prepared. Separately, in relation to an assessment of present suitability, it is important for the PCRC to inquire into historical conduct because, to the extent that past conduct points against suitability, the identification of that conduct and any remediation of it is relevant to an assessment of present suitability. Similarly, an inquiry into and understanding of the future intended conduct of relevant entities, such as their intentions for future remediation, or even merely their intention to maintain existing improvements or currently effective practices, also speaks to present suitability. Senior Counsel for Crown engaged yesterday with Commissioner Jenkins and also Commissioner Owen about whether there are obligations, responsibilities or expectations imposed upon the casino licensee, separate from its legal responsibilities or other express regulatory requirements that derive from the special nature of a casino licence and are relevant to an assessment of suitability. The effect of the Casino Control Act is that a person must be suitable to be granted a casino licence. The PCRC will need to consider whether that suitability requirement, coupled with the particular features of a casino licence, that is, the right to carry on a heavily restricted activity, and the activity the subject of the licence, being casino operations, being associated with particular risks, such as the risks of gambling-related harm, exploitation by criminals, and the facilitation of money laundering, suggest that a suitable person is one who meets an expected standard of conduct independently or irrespective of direct express regulation to reasonably mitigate those risks. That need not be an abstract notion incapable of sufficiently precise conception or description, as Senior Counsel for Crown submitted yesterday, any more than it might be said that it is impossible to articulate and understand what is meant by a person needing to be fit and proper to be a legal practitioner or a medical practitioner. And the consequences in the case of a casino licensee would sound in an assessment of suitability or otherwise to be or remain a licensee. In regard to future remediation, Counsel for GWC submitted that the PCRC ought to consider whether Crown's remediation program gives the PCRC a high level of confidence that change is imminent and to be sustained over the longer term. Senior Counsel for Crown, on the other hand, urged that the benchmark is somewhat less than that, being what is reasonably foreseeable as to the prospects of remediation. Whether one or other of those tests applies, or some other test, such as the probabilities or likelihood of remediation continuing and being maintained in the medium term, there are some particular matters relevant to this issue for the PCRC to reflect upon. The first is to carefully consider which aspects of Crown's remediation program have properly been the subject of evidence and which have not. Broad assertions that, for example, the financial crime risk program, quote, could be the most sophisticated, end of quote, in the casino industry, or that its responsible gaming program is world leading, in the absence of any evidence to support those assertions, may need to be put to one side. Where there is an absence of evidence or only limited evidence as to the content or intended implementation of one or more aspects of Crown's remediation program, it may be relevant to consider the reason why. In particular, whether and to what extent Crown has been afforded the opportunity to bring forward evidence and has not done so to assist the PCRC's inquiry either completely or at all, and if it hasn't, why it hasn't. the PCRC may need to carefully consider the weight to be given to evidence where an absence of evidence or limited evidence is apparent in respect of the remediation path forward. A related issue on this topic is that particular matters which may be in a state of flux and which might therefore create a degree of uncertainty about the path forward for Crown, and in particular Perth Casino, may bear on an assessment of suitability. Such matters could include the absence of a present or pending appointment of a CEO of the Perth Casino, the absence of an interim COO appointment, the likelihood and consequences of the implementation of the recommendations of the Victorian Royal Commission as to the requirement for separate board and senior management for Melbourne Casino, and similarly the likelihood and consequences of the Blackstone Group's acquisition of the CRL shareholding. Specifically in relation to those last two matters, whether they create uncertainty in respect of the leadership team upon which the remediation of Perth Casino's systems and culture depends is something that would need to be considered. Crown submitted to the PCRC yesterday in terms that while the corporate structure operation of the Perth Casino could be simplified, it does not bear relevantly on the assessment of suitability. Yesterday too, Commissioner Owen engaged with Senior Counsel for Crown about two potential breaches of the obligations imposed by the Burswood Property Trust, insofar as Burswood Resort Management Limited seemingly does not manage the trust operations, that is the casino operations, and Burswood Limited as unit holder seemingly involves itself in the operation of the casino licence. Senior Counsel, if I understood it correctly, submitted in terms that such breach was not of relevance to the question of suitability because even if such acts were in conflict with the provisions of the trust deed, they were consented to by the trustee. The PCRC will need to consider that submission, and Commissioner Owen has invited Crown to make further submissions on that topic. Together with the terms of the state agreement and what that calls for in terms of compliance with the trust deed is one matter that will need to be considered. Separately, the PCRC will need to consider how the corporate structure adopted in fact by the Burswood entities sits with the regulatory framework, such as Section 19, subsection 4 of the Casino Control Act, which in terms does not permit any person other than the licensee to conduct games at the Perth Casino, and Section 24, which empowers the GWC to give directions only to the licensee in respect of gaming operations. Another matter that the PCRC may wish to take into account when considering those submissions includes whether the complexity of the structure, the corporate structure, makes it difficult for those individuals who have oversight of the companies within the structure to develop a coherent and unified view about which entity is responsible and accountable for the governance and management of Perth Casino, whether Burswood Limited's business includes relevantly the operation of the Perth Casino, and if so, whether it can be said as a matter of substance rather than form that its head office is located in Western Australia, as effectively required under the state agreement through mandatory articles of the company's constitution. The CPH parties and Crown have both submitted in terms that the suitability of the CPH parties should not be considered by the PCRC. The first reason given is that none of the CPH parties are expressly made the subject of inquiry in the terms of reference. However, the PCRC may wish to consider whether relevant conduct of other entities or individuals bears upon an assessment of the suitability of the entities that are nominated in the terms of reference. Shareholders who have been or are in a position to influence the conduct of those entities are potential members of that category, as are individuals such as past and current directors of the companies referred to in the terms of reference and their senior management. The second reason given by the CPH parties is that the question of the influence of any CPH parties upon any of the Crown entities is, to use the expression of Senior Counsel, extinct and not merely dormant, by reason of undertakings that have been given. Whether it is possible or indeed necessary for the PCRC, in order to assess the suitability of the nominated Crown entities, to reach a level of satisfaction that there is no prospect whatsoever at any time in the future of influence by a CPH party upon the Crown entities is open to question. The task for the PCRC may lie more modestly in being able to conclude what is probable, both in terms of the exercise of influence or not, in fact, and over what time frame. Further, an assessment of the relevant past conduct of the CPH parties may expose systemic deficiencies in the governance or management or both of the Crown entities, which are important to identify and consider the extent to which they have been addressed. A related topic concerns the submissions made by Senior Counsel for the CPH parties this morning about the recommendation made by the Victorian Royal Commission for a cap on CPH's shareholding in CRL. Whether a recommendation of that character falls within the PCRC's terms of reference will need to be considered. Were the PCRC to conclude that it does, the residual question would be whether such a recommendation should be made. A consideration of that latter matter would have regard not only to an examination of the factual basis on which such a recommendation would be premised, as Senior Counsel submitted this morning, but also other matters, including whether the existing legislative framework already provides a mechanism for addressing the mischief or deficiency which such a recommendation would seek to address, or whether there are other alternative recommendations which might be more appropriate for the regulatory context here in Western Australia. Senior Counsel for the CPH parties also engaged this morning with Commissioner Jenkins on the topic of the GWC's submission that the PCRC should recommend in substance legislative amendments to allow for this inquiry and its report to be treated or deemed an inquiry for the purposes of Section 21A, subsection 5 of the Casino Control Act. Without rehearsing that discussion, some further matters for the PCRC to take into account when considering the GWC's submissions are these. First, aside from the question which will need to be considered of whether the terms of reference permit such a recommendation to be made, consideration may also need to be given to whether this inquiry could be regarded as a suitable proxy for an inquiry under Section 21A, subsection 5. There is some commonality between the language of paragraphs 1 to 5 of the terms of reference and certain provisions of the Casino Control Act to do with determinations by the Minister about whether an applicant for a licence is a suitable person or whether a close associate of the licensee remains a suitable person. Although it should be noted that the terms of reference expressly define what is meant by a suitable person, the Casino Control Act does not. Further, those statutory provisions to which I've just referred and which reflect the language of the terms of reference are not directly referable to the circumstances in which the Minister may direct an inquiry under Section 21A. Finally, the administrative decision of a Minister to direct an inquiry under that provision involves a consideration of the public interest, not in a general sense, but as that term is expressly defined in Section 3 of the Casino Control Act. Finally, I'll make some summary remarks about harm minimisation. Both GWC and Crown made submissions to the PCRC yesterday to the effect that each of them had observed their responsibilities in relation to harm minimisation. In the case of GWC, it was said that GWC had always placed considerable emphasis upon harm minimisation. Reminding ourselves that one of the primary focuses of this inquiry is upon the effectiveness or otherwise of systems and processes, that submission will fall to be assessed by reference not only to the approach or attitudes of individual members, but by reference to an examination of the regulatory structure imposed by the GWC to mitigate the risk of gambling-related harm, such as the existence or non-existence of directions to the licensee, inspection and audit procedures, policies, research and the like. In the case of Crown, it was said that it had not in the past failed to recognise its responsibilities, and a number of points were iterated to support that general submission. One was that Crown should not be judged as to expectations that were not made clear to it at the time. Another was that harm minimisation is largely unregulated in Western Australia. On those points, the PCRC will need to consider whether the special nature of the licence has always imposed, and accordingly Crown should have always appreciated, an expectation upon it that the licensee would do what is reasonable to mitigate the risk of gambling-related harm at Perth Casino. As to the general submission that Crown has not in the past failed to recognise its responsibilities, it will be relevant, among other things, for the PCRC to consider the extent of changes to Crown's RSG system in recent times and what that may say about the adequacy of the system in the past. Going forward, Perth Casino's remediation program for harm minimisation in particular will need to be considered in the way in which I've described earlier in respect of its remediation program more generally. The quality and completeness of the evidence provided to the PCRC about that program will be of relevance in that regard. May it please the Commission.
Thank you, Thank you, Ms. Cale. We're also grateful to you for your assistance and submissions. In accordance with our commitment to procedural fairness, I would like to invite the Council for the Interested Parties who have been given leave to make oral submissions to make any submissions in reply, strictly in reply to what Council Assisting has said. Is there anyone who would like to avail themselves of that opportunity? No? All right. Then that brings us to the conclusion of the public hearings. On behalf of the Commissioners, can I express our gratitude to the interested parties, to their counsel and solicitors, to counsel and solicitors assisting the Commission, the Secretariat of the Commission, our IT and transcript providers and other contractors, and to the Western Australian Industrial Relations Commission for their assistance in providing their physical facilities. I'm not going to name individuals. They will be recognised in the final report. But having said that, I think it would be remiss of us as the Commissioners not to place on public record our sincere gratitude to Mr. Daniel Davies as our Project Director, whose expertise, energy, enthusiasm and diligence has got us to the place that we are. And I can now say with some relish that the hearings of this inquiry are now adjourned indefinitely.